Hello everyone, and welcome. I'm excited to kick off today's presentation. Today, we're diving into a topic brought to you by Continuous Learning Development. This is the first slide, and you can see the copyright 2020 by Continuous Learning Development right here. Over the next few minutes, we'll explore some key ideas and insights that will help us grow and learn together. So let's get started. Today, I want to talk about the literal meaning of the term Ijtihad. It essentially refers to the concept of exerting maximum effort in performing an act. When we think about this, it's about dedicating ourselves fully to a task or a challenge. Now, on a more technical level, Ijtihad is understood as the effort made by a mujtahid, which is a qualified Islamic scholar, in seeking knowledge of the ahkam, or the rules of the Sharia. This process involves interpreting these rules to understand their application in different contexts. So, in essence, Ijtihad is about diligent and thoughtful effort to interpret and apply divine laws through careful reasoning. This effort is crucial because it helps bridge the gap between divine commandments and real-world situations. Remember, this concept underscores the importance of active, knowledgeable engagement in understanding Islamic law, which is fundamental to our overall theme of continuous learning and development. Let's take a closer look at the task of the mujtahid. After thoroughly studying the primary sources, the mujtahid's main responsibility is to discover the law through its literal interpretation. This means understanding what the texts explicitly state. But of course, sometimes the texts alone aren't enough. In such cases, the mujtahid extends the law to new cases that are similar to those mentioned in the sources, but can't be directly covered by just reading the texts. And beyond that, there are even situations where the law needs to be extended to entirely new cases that aren't addressed by either the literal interpretation or the similar cases. This process of extension is crucial because it allows the law to adapt and remain relevant as new circumstances arise. So, in essence, the mujtahid's task is a combination of understanding the clear, textual meaning and then thoughtfully applying that understanding to both similar and new situations. This ensures the law continues to serve justice and guidance effectively within the community. Let's explore the three modes of Ijtihad. First, we have the mode where the jurist stays as close as possible to the original texts. In this approach, the focus is on the literal meaning of the texts, meaning they follow the plain meaning rule to ensure fidelity to the original message. Next, the second mode involves a more specific type of analogy, which is confined to strict types. These are called qiyas al-mana and qiyas al-ilah. Here, the jurist draws connections based on shared meanings or causes, but within well-defined boundaries, ensuring the reasoning remains precise and consistent. Finally, the third mode shifts the focus from strict textual interpretation to understanding the spirit and purpose of the law. In this approach, legal reasoning aims to align with the broader objectives of Sharia, considering the underlying goals rather than just the literal texts. Together, these modes show us how Islamic legal thought balances textual fidelity with contextual understanding, adapting to different situations while maintaining core principles. Let's delve into the complete process of Ijtihad. First, the mujtahid must acquire the necessary qualifications to perform Ijtihad effectively. This means developing a deep understanding of Islamic sources and principles. Next, the mujtahid needs to understand the different forms of bayan, or clarification, and be able to identify the specific occasions when such clarifications are invoked. Recognizing these moments is crucial for applying the law correctly. The mujtahid then exercises all three modes of Ijtihad, if needed, to derive legal rulings from the sources. These modes include analogy, independent reasoning, and consensus. It's important to remember that this process is thorough and adaptable, depending on the situation. Additionally, understanding abrogation, or naskh, is vital. The mujtahid must identify when certain rules have been replaced by later commands from the lawgiver. This ensures that rulings stay current and aligned with divine intent. Finally, the mujtahid exercises preference, or tarjih, and reconciliation, or jam, among conflicting sources. This step involves carefully weighing the evidence to arrive at the most authentic and applicable ruling, especially when sources appear to conflict. Overall, this process highlights the meticulous and responsible nature of Ijtihad, ensuring that Islamic law remains dynamic, relevant, and true to its divine origins. Let's talk about the hukam of Ijtihad. Ijtihad is considered wajib, meaning obligatory, for those who have the necessary qualifications and the skills to perform it properly. This emphasizes the importance of expertise and proper training in deriving legal opinions. It's crucial to understand that the only time an opinion reached through Ijtihad can be considered invalid or ineffective is when it clearly contradicts a definite text, such as the Quran or authentic hadith. In such cases, the Ijtihad was not valid from the start, or ab initio. This highlights the significance of adhering to authentic texts and ensuring that our reasoning aligns with established sources. It also underscores the responsibility of qualified scholars to perform Ijtihad carefully, knowing that their efforts must be rooted in authentic knowledge. Let's talk about the qualifications of a mujtahid. First, having a deep knowledge of the Arabic language is essential, because understanding the original texts of the Quran and Sunnah relies heavily on language mastery. Next, a mujtahid must have comprehensive knowledge of al-Kitab, which refers to the Quran, and also of the Sunnah, the sayings and actions of the Prophet Muhammad. Additionally, knowledge of Amma, or scholarly consensus, is crucial, as it reflects the collective understanding of scholars over time. Another key area is understanding maqasid al-Sharia, which are the higher objectives and goals of Islamic law. This helps in interpreting laws in context. And of course, an aptitude for Ijtihad itself, the intellectual effort to arrive at legal rulings, is vital. However, in today's world, possessing all these qualifications doesn't necessarily make someone a mujtahid. The reason is that much of the authority and respect also depend on the acceptance by the community and scholars. It's not just about knowledge, it's about being recognized and trusted within the broader Islamic community. So, while these qualifications are fundamental, their real-world application and acceptance play a significant role in the status of a mujtahid today. Let's talk about interpreting the texts, focusing on the concept of bayan, or elaboration. Bayan can be understood as the distinctive way or style of expression that the Quran or other texts use. It's about how they communicate their message in a unique manner. Now, what's particularly important here is that we are looking at the mode of expression that actually has a legal impact. So, when we analyze texts, especially in a legal context, understanding this style or mode of elaboration helps us grasp the deeper meanings and the intentions behind the words. Moving on, the first mode of Ijtihad, which is central to our discussion, involves this interpretative approach. In essence, by examining how the texts are expressed, how they emphasize certain concepts or use particular language, we can derive legal rulings and understandings. This makes the concept of bayan crucial because it shapes how we interpret the texts in a way that impacts Islamic law and practice. Remember, this is all about connecting the style of expression to the legal implications, which is a key part of our overall study of Islamic jurisprudence. Let's take a closer look at the generally accepted types of bayan, which are 5 in total. First, we have bayan takrir, which is essentially about complementing or elaborating on a point to make it clearer. Next is bayan tafsir, or enabling expression, where we clarify or explain something to make it understandable. Then there's bayan taghir, which involves elaboration by exception, highlighting what is different or what changes from the norm. Moving on, we have bayan tabdil, known as conditional expression, where the meaning depends on specific conditions or circumstances. Lastly, bayan darura refers to elaboration by necessity, emphasizing what is essential or crucial to understand. Recognizing these types helps us grasp how different expressions serve distinct communicative purposes within our overall theme of effective communication. Let's talk about the interpretation of the texts, which is considered to be one of the most challenging parts of usul al-fiqh. This is because it involves understanding how to derive rulings from the primary sources, and there are two main methodologies that are used. The first methodology is practiced by the Hanafi school, and we refer to it as the method of the Hanafis. This approach tends to emphasize a particular way of reasoning and analysis that is characteristic of their school. The second methodology is followed by the majority of other schools, and it is known as the method of the Mutakallamun. These scholars often focus on rational principles and theological reasoning to interpret the texts. Recognizing these two methodologies helps us understand the different approaches scholars have taken throughout history to interpret divine texts and derive rulings. This distinction also highlights how diverse the field of usul al-fiqh is, and it connects to the overall theme of understanding how Islamic law is derived and interpreted. Remember, grasping these different methodologies is key to appreciating the richness and depth of Islamic jurisprudence. Now, let's explore the structure of interpretation according to al-Sarkasi, specifically for the Hanafi method. When a jurist approaches a text, they have several methods to establish the ahkam, or legal rulings. The first method is ibarat al-nas, which refers to the obvious meanings revealed through a plain reading of the text. This is about understanding the clear, direct message without much interpretation. Next, there's isharat al-nas, focusing on the connotations or the implied meanings of the texts. Sometimes, the text may not state something explicitly, but its connotations guide us toward understanding the ruling. Then, we have dalalat al-nas, which involves meanings that are implied or suggested by the texts, meaning that are not directly stated but can be inferred. Finally, there's iqtida al-nas, which looks at the meanings that are necessarily required by the texts, what the text mandates or demands in a given context. All these methods show how nuanced and layered the process of interpretation is within Hanafi jurisprudence, connecting the text's literal, implied, or necessary meanings to arrive at the correct rulings. Let's explore how the reading of the text to establish ahkam is supported by two main types of underlying activity. First, we have the literal forms through which the hukam, or ruling, is indicated. These include amr, nahi, or akbar. Essentially, these are direct commands, prohibitions, or reports that convey the hukam clearly and straightforwardly. The second type involves literal forms through which the meaning is indicated. Here, we are looking at concepts like am, khas, mushtarak, and mawwal. These terms refer to different types of generality or specificity in the language, whether a ruling applies broadly to specific cases or in an ambiguous way that requires further interpretation. Understanding these two layers helps us grasp how texts communicate rulings, either directly through explicit commands or indirectly through language that requires contextual understanding. This distinction is fundamental to how we interpret and apply Islamic legal texts, connecting directly to the overall theme of understanding the sources and methods of deriving ahkam. In this slide, we're looking at the literal method of establishing ahkam, or legal rulings, as practiced by the Shafis. According to Al-Ghazali, this method is divided into two main types. The first is dalalat al-saya, which involves proving a ruling through the syntax and grammatical form of the text itself. This is also called mantuq, or explicit meaning, because it relies on what the text clearly states. The second type is dalalat al-lafz, which involves proving rulings through implications beyond the direct syntactical meaning. This is referred to as gayer mantuq, or implied meaning, where we interpret what the text suggests beyond its obvious wording. These distinctions are crucial because they help us understand how scholars derive legal rulings directly from the language of the Quran and Hadith, ensuring that our interpretations are both precise and rooted in the original texts. This method underscores the importance of language and syntax in Islamic jurisprudence, especially within the Shafi'i school. Today, I want to talk about how dalalat al-lafz by gayer al-saya, or the indication of a word beyond its literal form, can be proved through 6 different methods. These methods help us understand the various ways language and context can reveal deeper or implied meanings. First, there's iqtida, which refers to implicit meaning. This is when the meaning isn't explicitly stated, but is understood from the context or the way the words are used. It's like reading between the lines to grasp what's implied. Next is ishara, or indication. This involves signs or cues that point us toward a particular interpretation. These might be subtle hints in the language that guide us without directly stating the meaning. Then we have ima, which also signifies indication, specifically of compatibility. It's about understanding that certain words or phrases are compatible within a given context, thus hinting at a particular intended meaning. Moving on to mafhum al-muwafaq, or the compatible higher-order meaning. This refers to a broader, more general understanding that aligns with the text and context, allowing us to interpret the message in a way that fits the overall theme or purpose. Then there's mafhum al-mukhalaf, which involves opposition or contrasting meanings. Sometimes, the context or the way words are used can suggest a meaning opposite to the literal one, indicating a different or nuanced interpretation. Finally, we have makwal, or rationalized meaning. This is when the meaning makes sense logically and rationally based on the principles of language and reasoning, helping us derive understanding beyond the literal words. All these methods show how rich and layered our language can be, and understanding them is essential for deep comprehension, especially in complex texts or nuanced conversations. Let's talk about the second mode of Ijtihad, which is reasoning by analog. According to the Shafis, this mode includes 3 different approaches to qiyas. First, there's the higher-order method, which involves more complex analogical reasoning. Then, we have the lower-order method, which is somewhat simpler. And finally, there's the equivalent method, which is based on finding exact similarities between situations. In contrast, the Hanafis limit reasoning by analog strictly to the equivalent method. So, this shows us how different schools of thought interpret and apply analogical reasoning in Islamic jurisprudence. Understanding these distinctions helps us see how diverse approaches can be used to derive legal rulings, all aiming to connect new issues with established principles. This mode of reasoning is a key part of how Islamic law adapts and evolves while maintaining its core principles. Now let's look at the method of discovering the underlying cause, known as mazalik al-ilah. Essentially, this involves identifying the nas, or the clear text, through indicators like the pointer or ima, or sometimes other hints that point us toward the underlying cause. Additionally, the concept of ima plays a crucial role here. When it comes to derivation of the ilah, or the cause, we use specific methods, including takhrij al-manat, which is the process of extracting the cause. These methods include munasaba, which refers to the suitability or appropriateness between the cause and the rule, doran, meaning the coexistence of the hukam, or ruling, with an attribute, and sabr and taxim, which involve division and testing of each attribute to eliminate unlikely causes. It's important to note that some scholars, like al-Shafi and other jurists, consider verifying the ilah in the far, or tahqiq al-manat, as a form of ijtihad or independent reasoning. This indicates how complex and nuanced the process can be. Al-Shatibi, a respected scholar, adds that this particular type of ilah, those that are far or distant, can never be fully determined or stopped. The reason for this is quite clear. It doesn't necessarily require a mujtahid or a qualified reasoner to establish it, because it's often beyond direct human ascertainment. So overall, discovering the underlying cause is a sophisticated process that combines textual clues, logical methods, and scholarly judgment, each playing a vital role in understanding the roots of Islamic rulings. In this slide, we're exploring the third mode of Ijtihad, which focuses on the interplay between general principles and the maqasid al-sharia, or the higher objectives of Islamic law. Most of these general principles are rooted in the hikmah, or wisdom, behind the laws. Essentially, a general principle in Islamic law acts as a broad explanation for the ilah, or the legal cause. For example, consider the rule that prayer is shortened during travel. The ilah, or reason, behind this rule is simply the journey itself. But if we reflect more deeply, we realize that the underlying wisdom is that a traveler typically faces some hardship, what we call mashaqqa. By focusing on this deeper wisdom, we can formulate a broader understanding. Whenever people face hardship, the law tends to grant some form of exemption. This highlights how Islamic law is flexible and compassionate, always considering the well-being and circumstances of individuals. So, in essence, this mode of Ijtihad helps us see the bigger picture, connecting specific rulings to their underlying wisdom and allowing us to apply principles more universally when circumstances change. Now, let's explore the concept of abrogation, or naskh, and preference, or tarjih. Starting with the doctrine of abrogation, the literal meaning of naskh is canceling or transferring. But in its technical sense, it refers to the process of lifting a legal rule through a later legal evidence. Essentially, when a new ruling comes that supersedes an earlier one, the earlier rule is considered abrogated. The text or evidence that causes this change is called nasikh, while the rule that gets repealed is called mansukh. It's important to understand that abrogation could only happen during the lifetime of the Prophet Muhammad, peace be upon him. So, when we say abrogation is claimed, we mean it comes directly from the lawgiver himself, not something that jurists invent or decide on their own. This underscores the divine origin and authority behind these rulings, which is a key point in understanding how Islamic law developed during the Prophet's life. Today, I want to clarify the distinction between naskh, which is abrogation, and takhsis, which is restriction. Sometimes, people get these two concepts mixed up, especially when discussing overriding laws or naskh juz'i, so it's important to understand how they differ. In the case of abrogation, or naskh, the original rule applies universally to everyone at first. Later, a new piece of evidence or a new ruling comes along and effectively removes that rule for certain people or under certain circumstances. It's like a blanket rule that initially applies to all, but then a subsequent ruling narrows its scope. On the other hand, takhsis or restriction is different. Here, the general rule was never meant to apply to a specific group from the very beginning. The restricting evidence is read together with the general evidence, so the rule wasn't universally established for that group from the start. Instead, the restriction is built into the original text or evidence itself, not added later. So, the key point is that abrogation involves a later evidence changing who the rule applies to, while restriction involves the initial establishment of a rule that already excludes a particular group. Understanding this helps us see how Islamic law carefully distinguishes between general and specific rulings, and how laws evolve over time. This distinction ties into the overall theme of understanding the methodology behind legal rulings, ensuring we interpret the texts accurately and appreciate the nuanced ways laws are applied and refined. Now let's look at the different types of abrogation. Essentially, abrogation happens in two ways. The first is explicit abrogation. This occurs when the lawgiver clearly states that a particular rule is no longer in effect. For example, the Prophet, peace be upon him, once said, "I used to forbid you from visiting the graves, but you may do so now." Here, there's a clear statement that the previous prohibition has been lifted. The second type is implicit abrogation. This is a bit more subtle because the lawgiver doesn't explicitly say that a rule has been abrogated. Instead, a new rule is introduced that conflicts with an earlier one, and there's no way to reconcile the two. An example of this is the period of iddah for a woman after her husband's death. The new ruling about iddah implicitly replaces or overrides the earlier rules without stating it outright. Understanding these two types helps us see how Islamic law evolves and how rulings can change over time through clear statements or through the introduction of new rules that conflict with previous ones. This is crucial in the broader context of legal development and applying Islamic principles correctly. Let's delve into the attributes of abrogating and abrogated evidences. First, it's important to understand that one text of the Quran can actually abrogate another text. This means that a later verse can supersede an earlier one when they appear to conflict. Moving on, the Mutawatir Sunnah, which refers to widely transmitted prophetic traditions, can also abrogate the rule of the Quran, and vice versa. Both are considered definitive, or qat'i, because their sources are direct revelation from Allah. Another point is that a khabar wahid, which is a report transmitted by a single source, can sometimes abrogate another khabar wahid. However, when it comes to ijma, or consensus of scholars, it cannot abrogate the texts. The reason is that ijma usually occurs after the death of the Prophet Muhammad, peace be on him, whereas abrogation happens before his passing. Lastly, abrogation is not permitted through analogy, or qiyas. This means one analogy cannot override or replace another. The rules surrounding abrogation emphasize the importance of the Quran and authentic Sunnah as the primary sources of Islamic law, with clear limitations on how and when abrogation can occur. This understanding helps us maintain the integrity and consistency of Islamic teachings throughout history. Let's delve into the rule of preference, or tarjih, and understand its core principles. First, we see that the explicit meaning, or nas, is generally preferred over the manifest, or zahir. This means that when there's a clear, explicit text, we give it priority over a more superficial or apparent interpretation. Next, the elaborated meaning, mufassar, takes precedence over the explicit meaning. This highlights the importance of detailed and clarified explanations over just the straightforward text. We also learn that the muhkam, which refers to clear and unambiguous rulings, is preferred over other, more ambiguous meanings. So, when there's a clear ruling, we lean towards it rather than uncertain interpretations. Another key point is that a rule established through a plain reading of the text, called ibarat al-nas, is favored over one derived indirectly through implications, known as israt al-nas. This emphasizes valuing the direct and obvious understanding of the text. Finally, if a rule is established through an indirect implication, or israt al-nas, it is preferred over a rule derived from its implication, dalalat al-nas. In essence, we prioritize interpretations supported directly by the text over those inferred indirectly. Overall, these principles guide us to favor clearer, more explicit, and directly supported meanings in our interpretation of texts, maintaining consistency and clarity in our understanding. When we talk about preference in legal reasoning, what really matters is the strength of the argument itself, not just the number of evidences we have. So, it's more about the quality and persuasiveness of the reasoning than simply counting pieces of evidence. Before we decide to favor one piece of evidence over another, the jurist's first step is to try to reconcile conflicting evidences. This is especially important when the two texts or pieces of evidence are equally strong. In such cases, the goal is to see if there's a way to harmonize or make sense of the conflicting points, rather than immediately dismissing one. This approach emphasizes the importance of a well-reasoned argument and highlights the role of judicial judgment in weighing evidence. It ties back to our overall theme, which is that sound legal reasoning relies on the power of the argument, how convincingly it can be made, rather than just the quantity of evidence. This underlines the critical role of the jurist's analytical skills in arriving at a fair and just decision. Taqlid, as generally understood, means following the opinion of the schools of Islamic law in matters of conduct. It's about adhering to established interpretations and rulings from recognized schools without necessarily questioning them. This approach provides a clear and consistent framework for everyday life and religious practice. On the other hand, Ijtihad is quite different. It refers to the process where an individual, when faced with a new or unclear issue, doesn't simply follow a school's opinion. Instead, they derive the rule directly from the primary sources of Islamic law, like the Quran and Sunnah. This means that someone practicing Ijtihad actively engages in personal reasoning and interpretation, applying these sources to their specific situation. It's a more independent and flexible approach, allowing for adaptation and new understandings within the boundaries of Islamic principles. So, when we talk about taqlid as a methodology, we're highlighting how it's traditionally viewed as a way to maintain consistency and unity in practice. But understanding Ijtihad reminds us of the importance of individual reasoning and the dynamic nature of Islamic law. Both methods have their place in shaping how Muslims navigate their faith and conduct. Today, I want to focus on taqlid as a fundamental basis for the Islamic theory of adjudication. Unlike Ijtihad, which involves independent reasoning, taqlid aims to establish a clear methodology for the faqih, or Islamic jurist, to discover and apply the law based on what has already been settled. Essentially, taqlid provides a structured approach that guides jurists in maintaining consistency with established legal rulings. When we think about the task of the faqih in Islamic law, it's quite similar to that of a modern judge. Both are tasked with settling issues that involve determining the law and the facts of a case, ensuring justice while adhering to legal principles. By understanding this comparison, we see how Islamic legal methodology aligns with broader judicial functions, emphasizing the importance of rooted, settled law in decision-making. Let's take a closer look at the term taqlid. It actually comes from the word qalada, and in a technical sense, it means following another person's opinion when the Sharia hasn't explicitly authorized doing so. Now, this is a very important distinction because not all taqlid is viewed the same way. There are two types of taqlid to consider. The first is prohibited taqlid, which occurs when someone follows another's opinion without any permission or proper basis from the Sharia. Engaging in this kind of taqlid is considered unlawful, as it bypasses the proper process of Islamic jurisprudence. On the other hand, we have permitted taqlid. This is when following the opinion of a qualified jurist is actually allowed by the Sharia. It's important to note that this isn't considered taqlid in the negative sense because it's based on proper authorization and scholarly consensus. As for the hukam or ruling, the prohibition of taqlid has been established, which means it's generally seen as haram unless it falls under the permitted category I just mentioned. Conversely, engaging in ijtihad, the process of independent reasoning, is considered wajib or obligatory because it helps ensure that we are deriving rulings directly from the sources of Islamic law. So, understanding these distinctions is key in our overall approach to jurisprudence and ensuring we follow the correct methodology in our faith. Now, let's talk about taqlid and how it functions within the Islamic legal system. Essentially, taqlid is implemented through the different schools of law, each with its own approach and methodology. When we look at the founder of a school, they have two main roles. First, they establish the usul, or the fundamental principles of interpretation. These principles serve as the foundation for understanding and applying Islamic law. Second, they use these principles to resolve specific legal issues, known as furu. This means they interpret and apply the law based on the established principles to address particular questions that arise. Because of this, the jurist who founded a school is often called a mujtahid mutlaq, or an absolute jurist. The key point here is that such a jurist is considered completely independent in their legal reasoning. They do not rely on taqlid or blind imitation of previous opinions. Instead, they exercise independent reasoning and interpretation. This independence is crucial because it highlights the importance of original, scholarly judgment in shaping Islamic law, especially at its foundational level. It also connects to the overall theme of our presentation, which emphasizes the diversity and depth of legal thought within the Islamic tradition, balancing tradition with scholarly independence. Now, let's talk about taqlid and the Islamic legal system. There are other jurists who are qualified to undertake ijtihad, meaning they have the expertise to interpret the law. These jurists follow the principles of interpretation that were established by their teacher, which guides how they approach deriving legal rulings. However, it's important to note that while they follow these principles, their opinions about the substantive law, what the law actually says, can differ from those of their teacher. This is because each jurist might interpret the principles slightly differently or apply them to new situations. When these jurists adhere to their teacher's opinion about the principles of interpretation, they are performing what we call taqlid. Specifically, this type of taqlid is known as taqlid fi al-usul, or taqlid in the principles of interpretation. The jurist who performs this kind of taqlid is referred to as mujtahid fi al-madhab. Overall, this process highlights how Islamic legal thought balances respect for foundational principles with the need for individual interpretation, ensuring the law remains both consistent and adaptable. Now let's take a closer look at the grades of the jurists. First, we have the Mujtahid Mutlaq, or Mujtahid fi al-Shar, who is considered the founder of the school. This is the jurist who has the authority to derive laws independently, based on their deep understanding of the principles. Then there's the Mujtahid fi al-Madhab, who follows the principles established by the founder of the school to derive law for themselves. They interpret and apply the principles within the framework set by the original school founder. Next, we have the Mujtahid fi al-Masail. These jurists are tasked with determining answers to new cases that weren't explicitly settled by the first two categories. They essentially fill in the gaps by reasoning through novel situations. Moving on, we encounter the Ashab al-Takrij. These are the jurists who clarify the law across all existing cases. Their role is to ensure that the law is well understood and properly articulated for all previously addressed issues. Finally, there are the Ashab al-Tarji. These jurists focus on choosing the stronger opinions within the school, aiming to bring more consistency and uniformity to the law. They help streamline legal rulings by selecting the most supported views. Understanding these distinctions helps us see how Islamic jurisprudence develops systematically, with different roles contributing to the richness and clarity of the legal tradition. Let's take a closer look at the category of the mujtahid. When we talk about mujtahids, we're referring to those jurists who are fully capable of performing the legislative function and determining what the law is. Essentially, these are the scholars who can directly derive laws from the primary sources, which are the Quran and the Sunnah. Their role is quite significant because they are laying down the law in the first instance, rather than interpreting or applying existing rulings. Within this category, we generally include the first two grades of mujtahids, the Mujtahid Mutlaq and the Mujtahid fi al-Madhab. The Mujtahid Mutlaq has the authority to derive laws independently across all issues, without being bound by any particular school. Meanwhile, the Mujtahid fi al-Madhab specializes within a specific school of thought, but still performs the same fundamental role of direct derivation. Understanding this distinction helps us appreciate how Islamic law is developed and how different levels of jurists contribute to its formulation. It's a key part of the broader theme of how methodology varies among jurists depending on their qualifications and the scope of their authority. Now, let's look at the second category of the faqiihs. These are the individuals who can be classified as full faqiihs, meaning they perform the judicial function. Essentially, they are the experts who discover the law by analyzing the general principles and then applying them to new cases. What's really important here is how they extend the law. They do this through reasoning from the principles, a method known as takrij. This process involves deriving legal rulings for new situations based on established principles, ensuring that the law remains adaptable and relevant. Within this category, we include various grades of jurists, highlighting that there's a spectrum of expertise, but all share the ability to perform this judicial extension through reasoning. This approach underscores the dynamic nature of Islamic jurisprudence, where scholars not only understand existing laws, but also actively interpret and extend them to address emerging issues. It ties into the overall theme of jurisprudence as a living, evolving discipline. Now, let's explore the role of the faqih, or Islamic jurist, in the legal system. Their primary task is to settle disputes by referring to the existing case law, ensuring that decisions are rooted in established principles. But their responsibilities don't end there. When needed, they are also tasked with extending the law, which involves interpreting and applying the general principles of Islamic law to new situations that may arise. This extension allows the law to remain relevant and adaptable over time. Additionally, if a completely new issue emerges, the faqih can formulate a new legal principle. However, this is not done arbitrarily. It must meet specific conditions laid down by the jurists to ensure consistency and legitimacy. Overall, the faqih plays a crucial role in maintaining the balance between tradition and adaptability within Islamic law, helping it to serve the needs of the community while staying true to its foundational principles. The established principles of Islamic law serve as a vital source for the faqih, or Islamic jurist. These principles are not just random ideas. They are systematically derived from the core texts of Islam, namely the Quran and the Sunnah. Some of these principles are explicitly stated within these texts, making their authority clear and direct. Others, however, are implied, meaning that jurists interpret and infer them based on the broader context of the texts. It's also important to recognize that jurists develop principles by examining various cases within Islamic law. By analyzing how similar situations were handled in the past, they can extract underlying principles that guide future rulings. This approach ensures consistency and coherence across different legal issues. Overall, these principles, whether explicitly mentioned or derived through careful reasoning, form the backbone of Islamic jurisprudence. They help faqihs make informed, fair, and contextually appropriate decisions, all while staying rooted in the foundational texts of Islam. And that brings us to the very end of our presentation. I want to thank you all for your time and attention. Remember, the key takeaway from this session is the importance of continuous learning and development in both personal and professional growth. The insights we've explored are designed to help you stay adaptable and innovative in a constantly changing world. As we conclude, I encourage you to take what you've learned here and apply it actively in your daily routines. Keep pushing forward, stay curious, and never stop developing your skills. Thank you again for being part of this journey with the CLD Institute. Your commitment to learning truly makes a difference. Wishing you all the best in your ongoing development.